now we'll talk about what is transfer impact assessment. So let's try and understand. See, you have understood what is a legitimate interest assessment, right? So transfer impact assessment is also conducting assessment and ensuring that the risks are mitigated or the risks are controlled and the risks are specified, whatever is there. So all such assessments are done with an intention of ensuring that compliance is met and risk is mitigated. So that is the whole objective of conducting these assessments. So a TI is an analysis by a data controller or a data processor of the impact of security implications. So this is conducted by a data controller or a data processor. So if a data controller sends the data outside European Union, then it is the data controller who will be doing it. If the data processor further sends it to a sub-processor, they will be doing it. Of security, of the impact and security implications. So what is the impact of sending data to a third country? And what are the security measures, organizational and technical measures taken here? To a country outside EEA that does not benefit from adequacy findings by the Commission. When it says that does not benefit from adequacy findings, it means that those nations are not included as adequate nations as per the GDPR, as per the European Union. What does a transfer impact assessment focus on? Right? It focuses specifically on whether the laws of the country to which the data is being imported or is being sent would permit government agencies access to that personal data. Like I said, I've told you this a couple of times before. In the US, there are such laws which bind the companies who have a headquarters in US that wherever the data is stored, right, even outside US, they will have to, if the government needs it, if the US government needs it, they are bound to give that data to US government. And that is why when you are trading with your US based companies, the countries try and keep the data within Europe and keep it in encrypted form so that when there are subpoenas, these data are not revealed to the US government. And you can see it on companies' websites also. If you go to Citrix's website or any other big firm's website, Google's website, they will have some information. However, such information that your company's data was subpoenaed or they were subpoenaed to disclose your company data is a confidential information, and that will be disclosed only when you as a privacy specialist have asked them that were you asked to give our data subjects data to your government, and they will tell you, they will send you the report that these many times you were subpoenaed for this, but we did not disclose your data because we do not have the keys to that data. Your data is encrypted, things like that. So that is why when you transfer data to a US based company, the European companies prefer having that data within Europe encrypted and the keys with themselves so that the US based company cannot access it. So the focus of the TI is to ensure that when you're sending data outside the European Union, the laws of the other country do not compel the company or the organization to disclose the data of European residents or citizens. Why do you need the additional protection? Why would they need the additional protection? Because transferring personal data beyond the reach of GDPR. See, the GDPR has a long reach impliedly because it's compelling all the countries to have a law as good as GDPR, or is bringing out things like SCCs and TIA. And given this fear, a lot of companies and organizations and data subjects within the European Union now prefer having a storage service within European Union. It is rare that they just let their data flow anywhere. If given a choice, or if the customers want a choice, the organizations do have to shift to more local storage platforms and not global storage platforms. So why is this additional protection required now? So transferring personal data beyond the reach of the GDPR may create additional risk for individuals because the level of protection that is offered by that law might be and in most cases is lesser than the GDPR, is lesser than what they're getting under the European and EA areas. And this may have in impact on individuals' ability to exercise their data protection rights, because if you do not have sufficient rights, how are you going to exercise those rights and protect them from unlawful disclosure of their personal data? Like I gave you this example, in US based laws, the government can access any data anytime as per their laws. And also, if the organization has their headquarters in US and they have data in other countries, the court can easily subpoena the organization to reveal the data. However, the protection and how technically the data has been protected would determine whether you are able to disclose that data or not. But yes, it is possible. Especially, in fact, there are many nations where this is possible, that the government can ask for some certain kind of data, and the companies will have to give that data. And the individual might not really be comfortable with it. For them, sharing their personal data to the government in certain sense is not acceptable. So that is why the GDPR has come up with this extra additional protections to ensure that the same level of protection, if not same, but something very close to that, the same kind of protection is given to data when it is outside the European Union or outside the adequate countries as well.